Good afternoon. Allahabad HC Pulse of ECI over non-disclosure of candidates asset verification reports. Infleet Union Government by Salil Tiwari, 18 August 2025 to 35 pm. The ECI claimed the Income Tax Department should publish candidates asset verification reports. The tax authorities denied such responsibility, and the HC held that the obligation prima facie lies with the ECI. The Allahabad High Court recently took strong exception to the failure of the Election Commission of India to publish verification reports of election candidates assets declarations, a mandate laid down by the Supreme Court more than 7 years ago. The public interest litigation filed by advocacy group Lok Frakari through its General Secretary and retired IAS officer S.N. Shukla highlighted that the Supreme Court, once February 2018 judgment required candidates asset disclosure in from 26th to be verified by the Income Tax Department, with the resulting report to be forwarded the ECI and made publicly accessible. Also read SC appointments. Retired Justice Sudhanshu Dulia as chairperson of Search Committee for Kerala Universities. Amit VC appointment row. However, despite correspondence between the ECI and Central Board of Direct Taxes (CBDT), the reports have not been placed in the public domain. Shukla, appearing in person, argued that the Commission's inaction undermines electoral transparency and violates the apex court's order. The ECA, represented by senior advocate O.P. Srivastava, countered by claiming that it was the responsibility of the Income Tax Department to publish the reports. This assertion was swiftly denied by counsels for the tax authorities, who maintained that no such obligation rested with them. Also read Allahabad HC upholds Noida's termination of cricket stadium contract over poor maintenance. Faced with this conflicting stance, the bench of Justice Rajan Roy and Justice Manjeev Shukla made clear its dissatisfaction prima facie. If at all this was to be done, it was to be done by the Election Commission of India. The court observed, emphasizing the ECI being statutory independent body must develop a mechanism to ensure such disclosure are available to the public. Court also noted the troubling delay. The judgment of Honorable the Supreme Court was passed in 2018, and we are now in 2025, and it has not been give effect. The order started underscoring the prolonged inaction in implementing a ruling central to electoral integrity. Also read Chhattisgarh HC tax su moto cognis of open knife trade, while ECI attempted to shift the burden onto the government of India. The bench pointed out that the Union of India had not been implicated as party in case given the nature of the PIL. Court directed the Ministry of Home Affairs be ordered as a respondent to resolve the issue comprehensively. The Deputy Solicitor General India, S.B. Bonde, has been asked to appear on the behalf of the Union Government and file an affidavit addressing both the right petition and the complaints gap in the implementing the Supreme Court directive. Thanks for watching.